Well, hello, everyone. Thank you again for joining us for another episode of Tailored Talks. On today, we are so grateful to have with us Ashley Myers Jackson in the office. And we are going to talk about something that's really important to us, to our community, and it's called estate planning. And so, Ashley, thank you so much. May I call you Ashley?
Of course.
Everyone,
of course.
Ashley's my cousin, so I just wanted to get that permission. So we're so happy to have you here. Thank you so much for your time.
Thank you.
We actually saw Ashley had a presentation at our family reunion this year. And we just thought it was so imperative that we share the information with so many others. And we hope that you do the same. So we ask that you like and share and subscribe to our YouTube channel. And if you would just sit back and join in and listen to what she has to say, I am sure that you'll be amazed at what she has to share with us. Ashley, my dad passed actually back in 2018. And we were grateful that we did have some things in place, but then there were some things that we did not have in place. And so we want to talk with you and want you to be able to share with us about estate planning. But before you do that, if you could tell us a little bit about yourself, we would really appreciate it.
So I'm Ashley Jackson. I am the owner of Myers Jackson Law Firm. I'm originally a Myers, so Ashley Myers Jackson. But I'm the owner of Myers Jackson Law Firm. We do estate and probate work in the Columbia area, and we also service the entire state. So we offer virtual and in-person services. In addition to that, we also do real estate work and personal injury as well. But estate planning is truly where our heart is, and so awesome. I'm excited to be here today to share more about that with you guys.
Great. And how long have you been doing estate planning?
So the estate planning side I've been doing now for about 8 years. I've been practicing law for a total of 15, but in various areas. But estate planning is about 8 years.
Good. And tell us, why do you think it's important for us, for families to have estate planning? And what is estate planning?
Got you. Well, yeah, let's start there.
Yeah.
So, estate planning is essentially a written plan for how things should either pass and how things pertain to you in the event that you become incapacitated or you ultimately transition. And I say transition as a word for death or dying. So it's essentially having things on paper to give us a good sense of what it is that you want done if those situations arise. It's important to have that because it eliminates a lot of things on the back end, like family rifts, or just things not necessarily going how you expected it to go. So it's important for us to know what to do in those types of situations. But also, passing down wealth, it's important that we do it in a structured way. Everybody's family is different. Everybody's children are different. I have 4 children, and all 4 of them are very different. And so if I want to pass certain things along and make sure that they preserve them as long as possible, I might need to have a written set of instructions that might be slightly different for each one of those kids. And so it's important to sit and think through those things, and hopefully things will play out like we design in our plan.
And so it's kind of like putting down my desires after death, what I want to happen and who to get what and all of that good stuff.
Yeah, it is who should get. So there are 2 sides to estate planning. There's a life phase to it, and then there's also a death phase to it. So the life side of it is you essentially saying, okay, if I, Yolanda, are in a position where I cannot assist myself with paying my bills or with making healthcare decisions, who do I trust enough to be able to do those things for me? So there's a life side to estate planning. And then there is a death side to it. And that's where we are essentially saying, okay, all the things that I own, who do I want to have these things? When do I want them to access these things? Under what circumstances would I like them to access these things? And then also, who do I trust enough to actually carry those wishes out when I'm gone? So it's multifaceted. It's not just the death phase, but there is also a life piece to it as well.
That's in the same document somewhat then.
It is in several documents.
Okay.
So with an estate plan, and again, most people think it's just that one document, like a will, or in some people's minds, just a trust. But an estate plan, a complete estate plan, includes about at least 5 or 6 other documents.
Wow.
So we have powers of attorney, which are the life documents. We call them life documents because they're effective while you're living, but they die when you die. And so those documents would be your financial power of attorney, your healthcare power of attorney. There's also a living will, which is a healthcare document that people oftentimes mistake for the last will and testament. But the living will is a healthcare document that will be in your plan, and also HIPAA authorization forms. Those are the life sections. The death sections would include things like your last will and testament, the document that most of us are well aware of. And then for some of us, the revocable living trust or some form of a trust would also be a part of your plan. So it's multiple documents, not just that one.
So tell us, Ashley, then what is the difference between a will and a trust, and how do I determine which I will need?
Yeah, that's a great question. So a will and a trust are similar in that they tell us exactly what should happen with your assets once you transition. But a will is subjected to the probate process. And so for those of you who might be familiar with probate, it's a court supervised process, and it's designed to remove assets out of a deceased person's name and shift them to a living person's name. So if you die with property in just Yolanda's name, depending on the type of property that it is, we may have to run it through the probate process in order to shift it to some other person. And wills typically give us instructions on that. A trust is designed, though, to remove assets out of your name while you are living. And so there's no need for the probate process on the back end. So a will and a trust are similar in that it tells us what to do with your things, but the trust is kind of like a will with superpowers. It is not subjected to the probate process, especially if we take the necessary steps to transfer the assets out of your name while you're living. Trusts are also good for assisting us with things like preserving wealth down the road. So for instance, you have 2 children and you have grandbabies. So at this point, you might want to leave a certain amount of money behind for your grandchildren, a certain amount behind for your children. But you might not want them to get all that money all outright. You might say, you know what, I would never even give you $30,000 outright while I'm living, so I'm definitely not doing it when I die.
Right.
So you might say, well, if you're going to go to college, then I'll make sure I pay for your books. Or
So
if
you'll have stipulations
there. So you have the ability to kind of control how things get distributed after you're gone with a trust, whereas it's not as easy to do something like that with a will. So whether or not you need one or the other, that's kind of determined by your situation. That's where you would sit with a lawyer and you would kind of give them a general idea of your family structure, all of the assets that you plan to leave behind, and then we could kind of talk through that to determine whether or not a will versus a trust is better suited for your situation.
Okay. So I know that there have been times when I've talked with families and they said, probate? I've never gone through probate. Or, once someone dies, they've just never done anything with their assets. What do you say to that? What is the recommendation, and what are the strategies, I guess, surrounding, or how do you determine, do I need to go through probate? Do I have to have a lot of money to have a will, or a lot of money to go through probate?
Yeah. So going through probate is oftentimes a necessary step, especially if you don't have any documentation. So for instance, if you die with assets in your name and you do not have a will, the state laws dictate what happens with your things. So the state has a set of rules. They're called the rules of intestate succession. They will dictate who gets what. So for instance, you're married, you have a husband, you have children. If you were to pass away with no will and we had assets in just Yolanda's name, then the state is going to say, well, your husband is entitled to 50% of your assets. Your children are entitled to the other 50%. So that's a necessary thing. And the probate court is going to be the space where we kind of go through and make sure that those things get done. If you have a will, you get to decide that, but the will still has to go through the probate process. So for most people, probate is still absolutely necessary. Now, we can set your assets in a position where we can eliminate probate, but that's going to require effort and work. So, for instance, if you own real estate and you're a realtor, so you understand, if you own real estate and it's in two people's name, there's certain language that we need to see in that deed to make sure that that property is not subjected to probate. And so that language would be joint tenancy with rights of survivorship. If we can legally structure everything where the probate realm is not necessary, then we can avoid it. But most people's things are not structured that way. Bank accounts, you can set those up to have beneficiary designations. Your life insurance can have beneficiary designations. Your retirement accounts, all those things can be structured that way. But if they're not structured that way, we need the probate process. And if you don't do it within a timely manner, we're going to need a bigger process even than just your standard probate.
Yeah, because I've actually seen and worked with some of our clients, wanting to sell a home. But, the person's name that's on the deed died 50 years ago, and they did not have a will. And so it just became one big snowball in trying to get that cleared up. So I think it's really important for us to know that we have to take care of our things and have to make sure that it's that the wills really are important. They really are. And is it always a 12-month waiting period for probate? What is generally the time frame for that? Do I have to, say for instance, I have a home or someone has a home and it's in their name alone. They're now deceased. So is there a waiting period in probate that the family would need to do? Because, of course, usually when people die, everyone comes like flies to a picnic and say, I want this and I want that. So how does that work if I die without a will and I have all this property in my name?
Yeah, if you die without a will and probate is needed, it will take, generally speaking, 8 months to 1 year from the time a person passes away to file probate or to complete probate, I should say. And that's if you start it like kind of right away. So some people wait a full year after a person dies to start probate. And the reason for that is creditors have time to kind of come in and say, this person owed me X amount of dollars. I'm trying to pull it from the estate. So our estate gives creditors that 8 to 12 month time period from the time a person dies for that to happen. So that's generally why probate takes that length of time. But after the 1 year mark has passed, probate can move relatively quickly if we are not having a bunch of fussing and fighting. So if let's say someone passed away, your client, you said the one that passed away and it's been 5 years, well, you said longer than that, but let's just say it was 5 years past the death date. We could probably move probate very quickly because we've already extended that time to creditors to file claims. They literally just have that 12-month period from the time a person passes. So oftentimes when people are starting probate within that time frame, it does take that long. But if we've already exceeded that 1 year time period, we can pretty much move it pretty fast.
Okay, that's good. So Ashley, what happens if, say, John Doe passes and he had the joint tenancy for Jane? When John passed, he did not update his will. Jane passed shortly thereafter. She did not have a will. So is that something that the state would need to decide on how to disperse all the assets? Or even a worse case than that, they had their children on there. One of the someone is deceased. That the child, one of the children, is no longer here, but that child has 4 children. So do they split up all those assets, or how is all of that?
Okay.
done?
So you just gave me a layered situation, which is good because this answers a lot of questions. So on the first front, you said John and Jane owned a piece of real estate together as joint tenants with rights of survivorship, correct?
Correct.
So when John dies, even though he did not have a will for that real estate, as an operation of law, it's going to kick back to Jane without the need for probate because the deed is structured in a way, or the contract is structured in a way where the law automatically pushes it back to Jane, whether we have a will or not. So that joint tenancy language does that. Now, when Jane dies, though, she owns this property by herself. There is no joint tenant with her. So when she dies in the law and she has no will, the law is going to then dictate who gets that property. Now, you said Jane has a couple of children. One of the couple children are still living, but then there's this one child who died, and now they have 4 children. So what happens is Jane's 2 other children who are living now own property with the 4 grandbabies of the child who died.
So what percentage? Say that there were 4 children. One is deceased. What percentage, or is it a percentage? Okay.
So the 4 children that she had would have had a fourth, and a fourth. So the 3 living, who are still living, they would each get their fourth. But the one who died, his fourth would then pass to his 4 children. So the 3 living each have a fourth, and then the 4 grandbabies share a fourth. And so you see how this can get very convoluted and complicated. And I'm sure John and Jane, neither of them probably expected that property would pass down like that. And so this is why you need a will.
Right. So thanks for sharing that. So what happens in terms of, the example that we're using, if we use that same scenario where all the children, it's divided up with each, do they have any tax consequences?
So there is no real inheritance tax in South Carolina. Like, we don't have that. But the federal government does have like an estate tax. But they allow you to pass, at this point, about close to $14 million per person without being taxed.
Oh, I didn't know that. Okay.
Yeah. So.
Oh, we're good.
We're good. I tell most of my clients, I'm like, listen, if you got $14 million, you need to reduce that. You can find me. I got a couple places you can put a couple million. But most people don't have a taxable estate at this point. But I will say that law is going to sunset this year. Where the number's going to fall, we don't know. It's anticipated to be about $7 million. To reduce back to 7, but still, most people still wouldn't have a taxable estate. That being said, we're not as concerned about the taxable estate. Now, for some people, that is a real thing, but for a lot of people, it's not. What we are concerned about, though, is sometimes the things we do in life that could create a taxable event down the road. So, for instance, when John and Jane owned that house together, they owned it. They probably bought it together. That's fine. If they were to sell it later in life, that's fine. They expect a capital gains issue. But when you add your children to title while you're living, when they go to sell that house down the road, the capital gains tax is going to look different than it should. Because we're going to revert it back to what John and Jane paid for the house. That will be our baseline. And then we will look to see what the kids were able to sell it for. And the capital gains tax will be based off of that. And so, for an example, let's say John and Jane paid $20,000 for their house, 40 years ago. And let's say when John died, Jane decided to add Joseph, their son, to title. If Joseph goes to sell this property down the road, the government is going to say, well, Joseph, it appears, paid $20,000 for this. And now he's selling it for $220,000. So we're going to tax him on the difference between that $20,000 and the $220,000. So this is why we say don't add your kids as owners in life. Let them inherit it, because when they inherit it, the baseline steps up. It moves up. So if John were to inherit that property from Jane, or Joseph were to inherit that property from Jane, and it was worth $200,000 when he inherited it, if he sells it for $220,000, we're only being taxed on the $20,000. So when we speak of tax consequences, generally speaking, we're talking more about that type of stuff than the inheritance tax, because most people won't reach that threshold.
Right. Okay, that's good. So tell us, I know that I've asked several questions. Share with us the questions that I have not asked that you feel that we need to know.
Yeah. So first of all, I think some of the top mistakes, we can talk about some of the top mistakes people make. I think DIYing things is the biggest mistake I have ever seen. Because it creates so many other mistakes. You know what I'm saying? Like it's that's kind of deciding to do these things on your own.
Because there's so much out there. Ooh, I don't want to pay that. Yeah.
It's just that. But, my thoughts are, so we take the most valuable things we have in life
work the
hardest for it, and then we decide to DIY how they get passed down. It doesn't make sense. So whenever people create wills and things on their own, a lot of the issues that I find, first of all, the wills don't always have everything that they should have in them. And we have technical issues a lot of times. Like, I've had situations where a mother created a will and then two of her children signed off as witnesses. Well, when you do that, you're basically eliminating yourself from the will. You can't be an interested party witnessing a will.
I didn't know that.
See?
Okay, so then, if I could stop you for a moment. So then are those wills acknowledged? Those that I may sit down in my home and write, and I'll have TJ and Janae witness off on it, saying that this is what Mom said she wanted. Is it first acknowledged in the court of law if I didn't file it or anything? And secondly, does that eliminate them from receiving anything?
A lot of times it eliminates them from receiving, at least under the way that you said in your documents. So it could revert back to the laws that the state has set. So let's say you left TJ 100% of everything, but TJ signed off on that will. The courts may say, well, you're an interested party and this will is not validly done. So now we're going to revert back to the state laws. And TJ, you're only entitled to 25% because your sister's entitled to the other 25 and your dad's entitled to 50. So it could
Terry's still going to be here.
Yeah. Look, I probably should have said it like I know we normally think. Yeah, he's gone, child, long gone. Because that's how we think too. I promise you. Men think they're leaving first. We think they're leaving first. Yeah, so Terry would have been gone, girl. 50% to TJ. But seriously, it would mess up the distribution based on what you would want done. And so that's not something that we want to see. The other thing, I've even had literally a 2-sentence will. I'm like, okay, well, who's the personal representative?
Yeah.
Who's like, it's just all of my stuff to this person. Okay, well, who's responsible for getting all this done? And it had no meat to it at all. And so these are the things that we don't want to see. We don't want you out here just doing things, or even understanding the fact that you open a door to so much conflict when you have a will. In general, this is why most people do a trust instead of a will, because wills have to go through the probate process, and we have to inform certain people about the process, even if they don't inherit from you. So if you disinherited TJ, but you left everything to me, when we filed this will, I have to tell TJ, hey, come on into the courts. Your mom did this. You need to be aware of this. But, oh, yeah, by the way, you're not getting anything. Do we really think TJ is just going to take that laying down?
Yeah.
Probably not.
Right.
So we open a door to things like fussing and fighting. So when you have situations in your family where you have blended families, or maybe you have children that you are estranged from, or you are married and separated for 30 and 40 years, you might not want to do a will. You might want a trust, something that doesn't necessarily open the doors to the courts for everybody to kind of come in and have the ability to contest.
Wow.
So it's a lot of things. It's a lot of things. And I just think I think it's wise to at least sit with a lawyer and get a good sense of where you stand in your situation based on your set of facts. A computer can't tell you that. So when you're DIYing documents, they're going to ask you your name, what you own, who you wanted to go to. They're not asking you about your situation, your family structure. They're not asking you any of that.
Wow. Okay, y'all. Listen, if you haven't heard anything else, I want you to share this piece. This is a question. I want to see how you will respond to it. Someone has been married. They were married for 20 years. They left. Never got a divorce. Never remarried, but they were staying with this other person for 10 years. never married that other person. So when that person dies without a will, then what happens to their money if the other wife is still living? The first wife.
If the other
or the
wife,
wife.
yeah, if the actual wife, the legal wife, we'll call it that. If the legal wife is still living, the legal wife still has legal rights. And the rights are, if I'm your sole heir, if you have no biological children, 100% of your things belong to me as the legal wife. If you have children, I split it with them, but at least 50% is mine, and under those circumstances.
Yeah.
And that's without a will.
Okay.
Now, if you add a will to the mix, and that person says, well, I know I'm technically married to this person, but I've been estranged from them for 40 years. I would like all my assets to go to this other person that I'm been in a relationship with. We can do that, but the legal wife still has rights. She can still say, well, I'm entitled to at least a third of your assets. But I tell people all the time, when you have a situation like what we're describing, you might not be able to fully disinherit that person, but you can at least do damage control. A third of my estate is very different than 100%. It's also very different than 50%. And so if you have situations like this is where we do the damage control. But the other part of that is, if I have a will, my lawful wife has to kind of come into the court and insert herself and say, I'm entitled to the third. But if you die without a will, the court is going to tell her, you're entitled and you're going to get X, Y, and Z. So it creates a whole nother situation if you don't have a will. Having a will at least gives you some layers of protection. And having a trust would be even better in that situation, because we're still not necessarily opening the door.
Right. Yeah. Okay. So how often do you recommend that we revisit our wills and the trust?
I think every 3 to 5 years, just on a standard, is 3 to 5 years is when you would want to look back.
Meaning updating it.
Updating it, yes.
If needed.
But I will also say, whenever life happens. So life tends to happen sometimes faster than the 3 to 5 year period. Like you may get divorced, or you might get remarried, or you might
grandbaby.
have that's right. You might have a grandbaby. Anything could happen that kind of changes the landscape. And whenever that happens, that's kind of a good time to look back at your documents. Sometimes changes need to be made. Sometimes they don't. I will say a good lawyer will draft things in a way where we try to anticipate certain things happening. So even if you don't update, we have kind of put certain language there to make sure that we can still capture those things. But updating is always the best. If you can get specific about things, I think that's always the best. And 3 to 5 years is generally when people need to do that.
Okay. All right. What happens if going back to the scenario somewhat, that, let's just make up another one. I'm now divorced and I'm remarried and I have done my will. I've updated it showing, my updated marital status and so forth and so on. But I did not update my 401k. And so I've been working, and my 401k I established when I was married the first time. So how does that work if the first wife is still on the 401k, but I'm now remarried? Who is the beneficiary? Does the beneficiary remain the same?
Yeah, so beneficiary designations are contractual. So usually whoever is the beneficiary on the account is who receives the funds.
Okay. So then it's important for us to know that when we're updating, we need to know what documents we need to update.
We need to update everything. Everything. And when especially in a situation like a divorce, even in some instances in anticipation of divorce, and you have to be careful, and I don't want to go too deep into that, because you have to be careful with changing things prior to a divorce, because you don't want it to seem like you're trying to just transfer things out and going afoul of the courts. But I will say, be thinking through these things. If you're anticipating a divorce, know the things that you have your spouse on, so that as soon as we're done, we can start updating things, changing things, because life happens. We don't know when we're going to pass. We don't know when something's going to happen. And you want to make sure that you're not putting yourself in those positions. I have seen it where spouses have literally collected hundreds of thousands of dollars in checks and they weren't even around.
Yeah.
I mean, so you want to update your bank accounts, your retirement accounts, your life insurance, your wills. If you have a trust, your trust. You want to update everything.
And that's not just in the case of that's all the time. Whenever life changes.
Whenever life changes.
I've been single, now I'm married, now I need to update everything.
Yes.
So we just have to be conscious and thinking of that. And I think oftentimes, especially in our community, we don't think about these documents because most of us say if we die. I was like, if we die?
Yeah, it's coming.
It's probably going to come unless we want to go in the rapture.
I'm telling you.
And that's what I'm claiming.
Yeah.
I'm going up in the rapture.
Slow down, Yolanda. I gotta get prepared. I ain't ready yet.
So we do want to let let everyone know that it is so important to make sure that we're not only prepared to live, we're prepared to die.
That's right.
And so I know that we were talking about the mistakes that people generally make during this process. So I kind of sent you in another direction.
That's
but if you'll continue with that, let us know some other mistakes for the remaining time that we have left.
Yeah. So other mistakes that I see. Like I said, when you have a trust too. So with a trust, when you have that document, it could be drafted very beautifully. But if you don't transfer assets to trust, it's not going to matter. So for instance, I told y'all probate is designed to move assets out of a deceased person's name and shift them to a living person's name. The only way for us to avoid probate is to structure our assets in a way where they're either not in our name or they're beneficiary designated. When you create a trust, you have to transfer assets to it, basically taking them out of your name in order for that trust to actually work. So that's another thing that I'll see. People will get like the Susie Orman Trust, or they'll even buy a trust from Office Depot, and they'll sign it, and then there's nothing in it. So like when you died, now it's like, okay, was anything ever transferred here? No. So now we still have to go through the probate process in order to kind of deal with these assets. So that's another mistake that I see.
And how does that transfer take place?
Through deeds. So for instance, most times we're transferring real estate to trust. So the same deed that was kind of signed when you bought your house or that you sign when you sell your house, we would create a new deed like that, transferring the property over. So that's what puts it into trust.
And that's something that you do in your office. Okay.
We do it. And in our office, we do it as a part of our package. So if you get a trust with us, we are going to retitle at least your residence. You want other properties retitled, we can do that too.
Okay.
So we do that. Another mistake that I see, hiding documents. So like we don't know where they are when a person dies. We know they have a will, but we don't know where it is. We thought they had some things, but we don't know where they are. And if we can't locate documents, we can't use them. So that's another thing. And then also I think for me, the discussions. People create these documents often, but they don't have discussions with their families. And so sometimes the intention is still lost and you still have people fussing and fighting because we don't really, we see these documents, but words can be interpreted multiple ways. But if you've had discussions with your children after you create documents to say, hey guys, this is what I'm expecting that this will look like. You see the documents here, but this is what I meant by that. Having those discussions is a big piece. And oftentimes, just like you said, in our community, we're not doing that.
No.
It's like, I'm not sitting up talking about death so I can die. Like, that's what we think. And we think just because we talk about it's going to happen. But we do need to have those discussions. So I would say that those are the things that I see most commonly that I think are big mistakes. But I will say, you said, we like to discuss life, but we also have to discuss death. And I don't necessarily view it that way. I don't view this conversation as a death discussion. What I view it as is a life-changing discussion.
That's good.
When we have life insurance, when we have retirement accounts, we have all these things that we can pass down. We are having our name called years and years and years down the road. If I can leave stuff behind for my grandbabies and they can in turn leave stuff behind for their children and their grandchildren, you know whose name they're going to reference? Grandma Ashley, or maybe not grandma, we'll figure another term, but they will reference my name for years and years and years. That's what legacy is. It's how long can your name actually be called and for what reasons.
Right.
We want to leave lasting impressions in a good way, not a bad way. We don't want people to reference what happened with us based on something that we didn't do. You know, grandma and granddaddy's house has been tied up for years. We don't want that to be the discussion. We want grandma and granddaddy passed down this house. This is a family house that we can all live in and go back to if we want to. That's the discussion we want to have. And to me, that means you never die.
Yeah.
You never die.
Yeah, that's a legacy.
That's a legacy.
That's a legacy. Awesome. And it's so important, too, to put this is a little off subject, but my banking days kicking in. We often, we say, let people know where things are. Have a safe deposit box. One of the things, or two of the things we always say, put your insurance policy in there and also your will or your trust. Put those in a safe deposit box. Let someone know where those items are. We've even started talking about doing our own obituary. You know, my dad, when he died, he really made it so much for us because he had everything down to the services, who he wanted on the services. So we had a chance, we could mourn and not be stressed.
Yes.
And so it really does. It takes a lot of stress off of you. So to, you know, have those conversations with your family. You know, this is my desire. You know, I don't know if you do it or not, but you know, I'm trying to make it easy for you.
Yeah.
But those are things that we want to have and put it in a place where someone knows they know, okay, this person has transitioned. I know where they have everything. All of your bank accounts. Write it out. This is the bank. I have this account here, this account there. They can go and pull everything out, and it just makes it so much easier.
It does. It does. When we do our intakes with our clients, we literally ask them a plethora of questions about everything, bank accounts, insurance, all of that. And we have that intake form that we keep. But when we're done with our process, we give our clients a binder with all of their documents in one location, and we purposely give them a bigger binder because the goal is for you to add things to that binder, like your life insurance, because if we can't find policies, how are we going to cash them in?
Right.
So we want everything to be in one location, but a part of the planning process is really getting you in order. Most people don't even know where their policies are. They don't know who the policies are with. So when we're asking all these questions, it's not just for our purpose, it's to get you organized and in line. Because like you said, it makes it so much easier down the road if it's all in one location.
Awesome. Thank you so much, Ashley. We appreciate it. What else would you like to share with us before we end today?
Well, one, I just want to say thank you so much for having me and for pushing this discussion. I think it's very important, especially in our community. It's important in general, but I think, you know, our community for the longest has not fully understood what to do and how to do it. And so I appreciate you taking the time to, you know, offer us this platform to do that. And I will also say, you know, I'm just excited. I'm excited to be a part of this great migration, I like to call it, for our community to kind of do the things that we need to do. I don't know if I have anything else.
Well, I tell you what, questions will probably come up. I want to thank each and every one of you for joining us, and I hope that you found one little nugget at least that you wrote down that you can take away. And this really is an important conversation that we want to have and we really need to have with our family and friends. And so if you all have any questions, Ashley Myers-Jackson, she's with Myers-Jackson Law Firm. She will give you ways that you can contact her at the office on her website, and we'll also put it down below so that you'll have it. So Ashley, if you would let them know how they will be able to contact you.
Yes, so our website is myersjacksonlaw.com, and then our email is info@myersjacksonlaw.com. We can also be reached at 803-394-4461.
Okay. Will you give that number once more, please?
803-394-4461.
Awesome. Thank you so much. We really appreciate it. And again, thank each and every one of you for stopping by and visiting with us today. And we pray that you have a wonderful life. Take care. Bye.
Bye.